Welcome to the Deep Dive, where we cut through the noise and get straight to the insights you need. Today, we're plunging into a truly fascinating and, let's be honest, often misunderstood area: legal research. You might picture, dusty law books or maybe just endless database searches, but it's so much more than that. We're talking about the systematic approach, the crucial distinctions and the surprising complexities that elevate legal research from just a task to, well, both an art and a science. For anyone who wants a real shortcut to understanding how laws truly shape our world, how legal decisions are actually made, and why precision is absolutely non-negotiable in this field, well, this deep dive is going to arm you with some serious aha moments.
Yeah, and what our source materials really do is illuminate the entire landscape,
Mhm.
from the foundational definitions right through to the nitty-gritty of real-world problem solving. We'll be extracting those essential nuggets of knowledge that truly define what it means to grasp and then skillfully apply legal information in a practical, impactful context.
Absolutely. Our mission today is really to equip you with the distilled wisdom from these materials, giving you a comprehensive, actionable understanding of what legal research truly entails, the systematic way it's done, and, crucially, why it's so incredibly vital. Get ready to peel back the layers and discover how to not just find the law, but to understand its nuances, identify relevant materials with confidence, and ultimately conduct legal research that really stands up to scrutiny. Okay, let's jump right in with the core definition. Our deep dive materials tell us that legal research is the process of identifying and retrieving information necessary to support legal decision-making. Now, on the surface, that sounds incredibly straightforward, almost, well, mundane, doesn't it? But I think for most of us, that simple definition masks a truly high-stakes reality. It's not just about finding facts.
Ooh, not at all.
It's about finding the right facts, the precise legal information that gives professionals the rock-solid ground they need to make critical, defensible decisions. It's the difference between a guess and a legally sound strategy.
That's precisely it. And this leads us straight into a fundamental distinction, one our sources really emphasize. What's the difference between research and writing? Because while they are, inextricably linked, often seen as two sides of the same coin,
Right.
they are indeed distinct skill sets. They demand different approaches. Think of research as the meticulous detective work. It's about diligently uncovering every relevant piece of information, sifting through, well, mountains of data sometimes, and identifying the true clues.
Okay, the detective work, I like that.
And legal writing, on the other hand, is about presenting those clues and your resulting conclusions effectively, persuasively, and crucially, in a legally compliant manner. You simply cannot have strong, credible legal writing without rigorous, accurate, and importantly, up-to-the-minute research backing it up every single step of the way.
So one really feeds the other.
Exactly. But the foundational, indispensable skill that underpins everything else, that's the research itself.
That distinction really solidifies the foundation. Now, many of our listeners are probably quite familiar with academic research, the kind where you write papers, explore theories, maybe delve into statistical analyses to support a hypothesis. But how does that intellectual pursuit compare to legal research? Our sources really highlight some critical differences, even though, yes, both types of research aim to address problems and involve intense analysis.
They absolutely do. And when we zoom out, consider the broader purpose. Academic research typically grapples with academic problems, which are often theoretical. It frequently relies on quantitative analysis, like statistical modeling, to prove or disprove theories, ultimately expanding the general body of knowledge. So, for instance, a scientific paper might use statistics to support a theory on, say, how climate change impacts marine ecosystems. It contributes to our collective understanding.
Okay, expanding knowledge.
But legal research, it operates with a fundamentally different focus and, frankly, a far more immediate, concrete goal. It deals with legal problems specific, often fact-driven disputes or questions demanding a binding legal answer. It employs a very specific set of legal tools, statutes, case precedents, regulations, and, crucially, it must locate relevant authority that would be binding on the applicable jurisdiction.
Binding authority. That sounds key.
It's the absolute core, the non-negotiable difference. Academic research seeks understanding, expands knowledge. Legal research seeks a binding answer that dictates real-world outcomes and shapes legal strategy. It directly impacts people's lives, businesses, their freedom. The stakes couldn't be more different. So a lawyer uses a binding case precedent from a higher court to argue a client's defense in court, directly impacting their freedom or financial future. A theoretical paper just wouldn't apply there.
That distinction truly crystallizes it for me.
Wow. So given this depth and precision, why dedicate so much time and effort to this? Why is legal research so absolutely critical for a lawyer or frankly for anyone dealing with the law? It really sounds like a foundational skill that just can't be overstated.
It is, honestly, without exaggeration, indispensable. And our sources unpack a multitude of reasons, all of which have profound real-world implications. Firstly, the law is an incredibly dynamic entity. It's not static, not carved in stone. It's constantly changing.
Right, it's always evolving.
Exactly. Acts of Parliament can be repealed, consolidated, meaning, several related laws are combined into one clearer, updated document or amended. Cases are regularly overruled, reversed, or questioned by later courts. Entirely new jurisprudence emerges all the time. This means any research undertaken for a client must reflect the current state of the law at that precise moment.
So getting it wrong isn't just a mistake. No, it could lead to professional negligence with really severe consequences. Secondly, legal research forms the absolute bedrock for supporting all legal decision-making. It provides the factual and legal basis for any advice given, any strategy formulated, or any action taken on behalf of a client. Without sound, current research decisions are, quite frankly, just educated guesses. And in law, guesses are extremely risky.
You definitely don't want guesswork there.
Absolutely not. Thirdly, it's essential for navigating complex legal issues where the answers are far from obvious. The law rarely presents simple, one-size-fits-all solutions, right? Research allows you to delve into those complexities, uncover nuances, and find the specific principles that apply. It's also vital for knowledge acquisition, where broad legal principles are applied to specific facts to acquire an in-depth understanding of a particular topic. That's how a lawyer builds expertise over time.
And it's not just a skill for seasoned practitioners, is it? Our sources highlight its crucial role in professional development right from the start.
Exactly. Law students and trainees dedicate a significant proportion of their time to legal research. It's how they learn to think like a lawyer, how to study, analyze, critique, and then apply legal material to new situations. Moreover, robust research is necessary to obtain truly thorough and accurate answers. A superficial search simply will not cut it in a legal context where precision is paramount.
And for courtroom battles.
Oh, absolutely critical. For advocacy and litigation, meticulous research helps advocates prepare effectively for court. It allows them to, as our sources vividly put it, destroy legal opinions of the adverse party by being exceptionally well prepared and knowing the law inside and out. And let's not overlook client value. Clients pay for expertise and good advice or service, and that is fundamentally based on sound, up-to-date research. It builds trust, demonstrates competence.
That makes total sense.
Now, here's where it gets really interesting. The real game changer. It's not just about finding an answer. It's about finding the precise, up-to-the-minute answers for the right time and knowing how to wield them to win arguments or secure the best possible outcome for a client. Imagine advising a client on, say, a property transaction, only to discover a week later that a key piece of legislation you relied on was repealed last month.
Oh, that would be bad.
Bad is an understatement. The consequences. Potentially missed deadlines, incorrect advice that exposes your client to significant financial loss, or even losing a case that could have been won. The financial and reputational implications for a legal professional are immense. This ties directly into what our sources call the role of legal research in the office. Law firms generate fees by selling the time lawyers spend solving client problems. And practical legal research is an important foundational step in that larger process. It demands work that is accurate, timely, current, carried out efficiently, commercially aware, and presented appropriately. It's basically the engine room of legal practice.
Okay, so now that we've truly grasped why legal research is so crucial, let's turn our attention to the actual raw materials, the legal sources themselves. Our deep dive materials make a very clear and fundamental distinction between primary and secondary legal sources, which sounds absolutely vital for any researcher to understand.
Oh, this classification is paramount. Absolutely. Primary sources are, quite simply, the law itself. These are the authoritative pronouncements that establish legal rules and principles directly. They are the actual building blocks of the legal system. Examples include foundational documents like constitutions, the supreme law, setting the framework. Then we have primary legislation, which covers both principal acts, like a major environmental protection law, and any amending acts that modify or update them. Subsidiary legislation also falls here. That includes rules, regulations, bylaws, ordinances enacted under the authority of those primary laws, think local council bylaws or government department regulations.
Got it, the actual rules.
Exactly. And of course, judicial decisions, judgments from courts, both reported and unreported, are primary sources. They interpret and apply the law, often creating binding precedents. In some places, international conventions and treaties and even customary law can also be primary sources. To give you a clearer picture, something like Hansard, which is the verbatim record of parliamentary debates, that's a direct legal record, or a bill, which is a proposed piece of legislation going through Parliament, these are direct instruments of the law, or records of its making. They are the raw, unadulterated statements of the law.
Okay, raw ingredients. What about secondary sources then?
Right. Secondary sources, on the other hand, are works about the law. They don't create law themselves, but they help to explain, describe, discuss, interpret, comment on, analyze, evaluate, and summarize those primary sources. Think of primary sources as the raw ingredients, the flour, sugar, eggs. Secondary sources are the cookbooks.
Ah, the cookbooks. I like that.
Yeah. They provide the recipes, techniques, and context to understand how those ingredients work together and what kind of, well, legally complicated dish you might create. Examples here include academic textbooks, scholarly journal articles, official reports, and legal commentaries. They provide invaluable analysis and guidance, often pointing you straight to the most relevant primary law.
That cookbook analogy really helps frame it. Now, with so many secondary sources available, it must feel like standing in a massive library trying to decide where to even start. Our materials give us a very clear checklist for what makes an ideal secondary source. It's not just about grabbing any book on the topic, is it?
Exactly right. When you're sifting through all that secondary material, you're looking for three key characteristics. Think of it like a researcher's GPS for navigating the information jungle. First, the ideal secondary source must be authoritative and current. This means it's written by recognized experts, leading academics, experienced judges, people like that, and it's been recently updated to reflect the latest legal developments. If you're reading a textbook from 1995 on internet law, probably not going to be very helpful.
Right, wildly out of date.
Completely. Secondly, it should be specific to your jurisdiction if possible. While general legal principles can be useful for background, a source directly addressing the law in the specific legal system you're working within will be far more relevant and, crucially, persuasive. And third, it needs to be detailed with regard to your specific topic. A broad overview might be a good starting point, but for in-depth research, you need a source that truly delves into the nuances and complexities of your particular area.
And why is authoritative and current so incredibly critical?
Well, because relying on outdated or unreliable information can honestly be worse than having no information at all in a legal context. Imagine basing a major legal argument on a case that was overturned last year that would be disastrous professionally and for your client.
Yikes. Okay, now here's a point that really resonates with me, and I suspect with many listeners, especially in our digital age. Many of us might instinctively think the internet, Google, holds all the answers for legal research. But our sources highlight a dangerous misconception there. I'll admit, like many, I'm probably guilty of that sometimes. Why exactly is relying on the free internet such a trap, especially for someone in law?
Oh, it's a classic trap. And a critical point our materials really hammer home. The sheer amount of information on the free internet, Google, Wikipedia, random blogs, whatever, has indeed fostered this dangerous misconception, particularly among students perhaps, that all the information needed for legal research can be found there. The crucial consideration, though, is the quality of information. Anyone can publish online, right? Websites frequently change, they disappear entirely, or they might even present outright misinformation. And crucially, nobody is formally responsible for ensuring the accuracy, currency, or impartiality of much of that content. This is a stark contrast to vetted legal resources. Our sources strongly recommend that you always begin any legal research with an authoritative source, a reputable online legal database, or a trusted printed legal resource. In fact, some of the very best works, the truly definitive analyses that have shaped legal thinking, are only available in paper form or behind a subscription paywall.
So those paid databases are worth it then?
Absolutely. This is precisely why commercial databases are so vital. Yes, they require payment for subscription access, but what you're paying for is meticulously curated, authoritative content that has been rigorously checked for accuracy and currency by legal experts. Let's take Halsbury's Laws of England as a perfect example. It's this authoritative encyclopedia providing commentary on the present state of all areas of English law, arranged alphabetically by subject. The printed version is massive, something like 103 volumes. Yeah. But the same content is available online via the Lexis Library subscription database. Halsbury's is particularly useful if you are researching a brand new area of law, maybe for a moot court or an unfamiliar client query, and you need to quickly find the most important cases, legislation, and commentary in that area. It provides a level of curated authority and depth that a general internet search simply cannot match. You wouldn't rely on a random blog post for brain surgery, right?
Definitely not.
Well, you absolutely shouldn't for critical legal advice either.
That Hallsbury's example really drives home the difference between just casual searching and actual professional legal research. And our courses even provide a fantastic visual roadmap for this structured approach, what they call the LexisNexis Standard Legal Research Process Pyramid. Sounds like a blueprint for reliability.
It truly is a blueprint, a visual representation of how to build reliable legal research from the ground up.
At the very base of the pyramid, you have the open web, LexisWeb, Google, Bing,
Yep.
which, as we just discussed, is useful for general background research, maybe getting some initial ideas.
But not authoritative. Exactly. It's clearly marked as not necessarily authoritative. It's a starting point, maybe, but not a place for definitive answers. Moving up the pyramid, you then access secondary authority. This layer includes esteemed resources like law reviews, treatises, practice guides, legal news. These provide analysis and, crucially, lead you to the next, more authoritative level.
Which is?
Primary authority. This is where you find the actual law. Case law, statutes, regulations, annotations. This is where the rubber meets the road, where you locate the binding legal principles. Finally, at the very pinnacle of the pyramid is Shepard's validation. This is a critical and sometimes overlooked step that ensures the currency and validity of your primary authority. Shepard's, for example, tells you if a case has been overruled or if a statute has been amended or repealed. It's absolutely vital.
So it checks if your sources are still good law.
Precisely. And tools like Lexis Advance, with its word wheel for intuitive searches, intuitive filters for narrowing results, and the legal issue trail for connecting related topics, they're all designed to make navigating these layers of information much easier and more efficient. What this pyramid really illustrates is the necessary progression. You start broad, maybe on the open web, but you must systematically narrow down and rigorously validate your findings with increasingly authoritative sources. It's not a straight sprint to the answer, it's a structured roadmap to reliability, ensuring the information you ultimately rely on is both relevant and absolutely sound.
Okay, so with this vast arsenal of sources and all these considerations at authority, how do you even begin a legal research task without feeling completely overwhelmed? Our materials outline a very clear 5-step legal research process that provides a systematic, almost choreographed approach. I imagine that's absolutely crucial for both efficiency and accuracy.
It's precisely that, a choreography, a logical sequence designed to prevent you from getting lost in the weeds, as you say. This systematic approach is absolutely vital for any legal professional. You don't just, jump into finding cases or statutes. There's a disciplined flow that needs to be followed.
Okay, walk us through it. Step 1.
The first step is to formulate a research plan. This might sound obvious, but it's so critical for setting your direction, defining your scope, and ensuring efficiency. Without a plan, you're just aimlessly searching, wasting precious time and resources.
Right, know where you're going before you start.
Exactly. Once you have a clear plan, the second step is to consult secondary sources. As we discussed, these provide essential context and an overview of the legal area, often guiding you to the key primary sources. Here, you'd be asking yourself, which secondary sources are the most authoritative and current for my specific jurisdiction? Am I looking for a comprehensive treatise like Halsbury's, or maybe a more focused law journal article on a niche point? This deliberate selection is key.
Got it. Get the lay of the land first.
Precisely. After gaining sufficient context and identifying potential primary leads, you then move to the third step. Consult primary sources. This is where you dive into the actual law, the statutes, regulations, and case law that govern the issue. The fourth step is to expand and update primary law. This isn't a one-off, it's a continuous, iterative process. You need to ensure that the primary law you found is current and complete, taking into account any recent amendments, legislative changes, or new judicial interpretations.
That keeping it current theme again.
Always. And finally, the fifth step is to analyze and organize results. This isn't just about collecting information, it's about making sense of your findings, identifying patterns, maybe reconciling conflicting authorities, and ultimately synthesizing it all into a coherent, actionable answer. It's a cyclical process. You plan, you get context, you dive deep, you keep it current, and then you make sense of it all.
That makes perfect sense. But legal research isn't usually done just for the sake of it, is it? It's almost always in service of solving a client's specific problem, which feels like a much broader scope than just finding legal principles. Our sources provide an excellent problem analysis model from the University of Law back in 2015 that really takes us through the full journey of legal problem solving, integrating research into a larger strategic framework.
Oh, this model is a cornerstone of practical legal work. It makes it crystal clear that research isn't an isolated task. It's intricately woven into a larger problem-solving framework. It lays out 8 distinct stages, and understanding the why behind each is absolutely crucial for any lawyer.
Okay, let's break it down. Stage one.
The first stage is to identify the objective. You must establish what your client actually wants to achieve, because this objective will drive your entire approach to solving their legal problems. If you don't know the destination, you can't possibly plan the most effective route, right?
Right. Start with the end goal.
Exactly. Next, you gather relevant material facts. This involves asking probing questions, listening intently, obtaining all pertinent facts from the client and maybe other sources. Because the law is always applied to specific, unique facts. You might even need to circle back here if you realize you need more information.
Facts are crucial. Then what?
The third stage is to identify relevant law. From the key facts you've gathered, you'll derive the specific issues of substantive law, what the law is, and procedure, how the law is applied, that need to be investigated. These issues become the focus of your targeted legal research. Then, stage 4, you apply law to the facts. This requires sophisticated legal reasoning, similar to how judges decide disputes. It's not just stating what the law says, it's showing precisely how it interacts with the specific circumstances of your client's situation. You might need to step back here too, rethink things if your initial application reveals gaps.
So connecting the dots between law and the specific situation.
Precisely. The fifth stage is to identify possible solutions. Once you've established that relationship between facts and law, a range of potential solutions should emerge. Brainstorming is useful here, and importantly, the model advises you to always consider the possibility of doing nothing. Sometimes the best legal advice is to avoid action that could make things worse.
Interesting. Doing nothing as a strategy.
It can be. Following that, stage 6, you consider advantages and disadvantages for each identified solution, carefully weighing the rewards and risks involved. This is where strategic thinking and commercial awareness really come into play. What are the costs, the timelines, the potential outcomes? Then, stage 7, you advise on the appropriate solution, guiding the client based on your thorough analysis and recommending a course of action. And the 8th and final stage is to present solutions in appropriate form, perhaps a detailed written report, clearly and concisely communicating your findings, reasoning, and recommendations.
Can you give us a quick example?
Sure. Imagine a client comes to you because their new neighbor plays loud music late at night. You wouldn't just search loud music law. First, identify their objective. Stop the music. Compensation. Force the neighbor to move. Then, gather facts. When, how loud, how long. Try talking to them. Then, identify relevant laws, local ordinances, nuisance law, property law. Apply those laws to the specific facts. Does it meet the legal definition of nuisance? Then, brainstorm solutions, polite letter, mediation, legal action, weigh pros and cons, cost, time, damaging relations. Finally, advise them on the best path, maybe starting with a formal demand letter. It's that full cycle.
That comprehensive model truly breaks down the entire process from a client's initial problem right through to a solution. Very clear. Now, shifting back to sources for a moment. When you're sifting through cases, which are obviously a cornerstone primary source, you quickly realize not all are created equal. Our sources give us 4 characteristics of the ideal case to look out for, helping researchers prioritize and evaluate judicial decisions for maximum impact. What are those?
Right. When it comes to case law, a truly impactful and persuasive judicial decision possesses specific qualities that give it significant weight and authority. The first characteristic of an ideal case is that it must be on point. This means it directly addresses the legal issue you're dealing with, rather than just, tangentially touching upon it. The more precisely a case aligns with your facts and legal question, the more persuasive it will be, like hitting the bullseye.
Makes sense. Directly relevant.
Secondly, and crucially, it needs to be binding authority. As we mentioned earlier, this means it's a decision from a higher court, or sometimes the same court within the same jurisdiction, that must be followed by lower courts in that jurisdiction. A decision from a different jurisdiction or a lower court might be persuasive, maybe insightful, but it doesn't carry that mandatory weight. That's fundamental to common law precedent.
Must be followed. Got it.
The third characteristic is that it should be recent. While older landmark cases can certainly be foundational, a recent case reflects the most current interpretation of the law. This is particularly important because legal principles evolve, and a more recent decision accounts for those developments, ensuring your argument is built on the most current understanding. Finally, an ideal case is often a leading case. This refers to a landmark decision that established a significant legal principle, often breaking new ground or clarifying an area of law in a profound way. These cases become essential reference points, shaping the legal landscape for years.
On point, binding, recent, and a leading case.
Those are the ideals. Now, the sources wisely note that few cases will actually fulfill all these characteristics perfectly. It's often a balancing act, a judgment call based on your specific research needs. But knowing these criteria helps you prioritize and evaluate your search results, ensuring you're working with the most persuasive and authoritative judicial decisions available. You're always aiming for the strongest possible precedent.
Okay, so beyond the systematic process and understanding different sources, what are the actionable strategies for making your legal research truly effective? Especially when, let's face it, time and resources are often tight. Our material offers some excellent tips for success from the University of Law, from that 2015 source again, that really focus on maximizing efficiency and impact.
Yeah, these tips are incredibly practical, moving beyond the what to the how. The first is to analyze the client's problems carefully so that you are crystal clear about their objectives. This loops back to our problem analysis model, right? Without a clear goal, your research will inevitably be unfocused and inefficient.
Start with the why.
Exactly. Secondly, you need to devise strong search terms based on relevant legal concepts. This is like having the right key to unlock the right information in a vast library or database. If you're looking for negligence in dog bites, just searching dog or bite will flood you with irrelevant noise. You need precise terms that capture the legal concepts involved.
Good search terms are crucial. What else?
Thirdly, select the most appropriate research tool and learn to use different tools and their indexes properly. Do not cut corners. This is such a powerful piece of advice. Mastering the specific features and search functionalities of commercial databases like LexisNexis or Westlaw, or even the detailed indexes of physical law reports, is crucial for efficiency. Trying to get by with just a superficial understanding will inevitably lead to missed information or wasted time.
And why is not cutting corners so vital here?
Well, because as we've touched on, the legal consequences can be incredibly severe. A small oversight due to inadequate research or maybe an improperly used tool can have massive, irreversible repercussions for a client's significant financial loss, even loss of liberty sometimes. I remember once seeing a new associate confidently citing a case that had actually been overruled 2 years prior. Thankfully, we caught it in review, but it was a stark reminder of that always update rule and the absolute importance of knowing your tools inside out.
Wow, close call. Okay, what are the other tips?
The fourth tip is to always update your information. We keep coming back to this, but given the dynamic nature of law, that is absolutely non-negotiable. What was true yesterday might not be true today. Fifth, you must present this. Present the information in an appropriate form. Clarity, conciseness, strict adherence to professional standards in reporting your findings, these are as important as the research itself. A brilliant finding poorly communicated is almost useless. And finally, do not be afraid to ask for help. Legal research can be incredibly complex. Acknowledging that complexity and seeking guidance from experienced colleagues, supervisors, or specialist librarians is a sign of wisdom and professionalism, not weakness. Collaboration can save huge amounts of time and ensure thoroughness.
That's great practical advice. You mentioned the dynamic nature of law again, and this brings us back to one of the most vital aspects, staying current. It sounds like a constant battle against obsolescence. How does one ensure that research reflects the very latest legal landscape and avoid those overruled case pitfalls you mentioned?
It's absolutely a continuous process, not a one-time task. Our sources identify two main forms of legislative updates that researchers must monitor diligently. The first is simply later amending legislation. This refers to new laws or changes to existing laws that can fundamentally alter the substance or procedure of a legal area. An act might be partially repealed, a new section added, an entire statute overhauled. For instance, a new Data Protection Act could completely change how businesses handle personal information, superseding previous regulations. It's crucial to know if the version of an act you're looking at is the most current one in force, or you risk giving completely wrong advice.
Okay, new laws and amendments. What's the second form?
The second principal form of update comes from statements of interpretation by judges in subsequent cases. Even if a statute itself hasn't changed on paper, how courts interpret and apply that legislation in new contexts can fundamentally alter its practical meaning and application. A landmark case might clarify an ambiguous provision in, say, a contract law statute, or even introduce a whole new way of understanding an existing legal principle in the digital age. This ongoing judicial interpretation is often called common law development.
So the courts shape the law too, even without new legislation.
Exactly. What this ultimately underscores is that law isn't static. It's a living, breathing body of rules that requires constant vigilance to understand its current form and application. A truly skilled researcher doesn't just find the law as it was written, they understand its trajectory and how it continues to evolve through both legislative action and judicial interpretation.
Let's talk about something that often gets overlooked in the rush to find answers, but sounds absolutely critical: recording your research. Our sources make a truly compelling case for accurate references and detailed records. I gather it goes far beyond just remembering where you found something. It sounds almost like forensic documentation.
Forensic documentation is a perfect way to put it. This point cannot be stressed enough. Our sources explicitly say, stop and make notes at every stage. Accurate references don't just save you immense time later if you need to revisit something, they are absolutely essential for accountability and professional integrity. Your supervisor, a colleague, maybe even a court later on, may question an answer or inquire about the specific steps you took to arrive at your conclusions. Comprehensive recording provides that undeniable audit trail, validating your work and demonstrating your thoroughness.
Okay, so it's about proving your work. What exactly should you record?
Think of it as answering the 5 W's and 1 H for your research. Who published it? What is it? When was it current? Where did you find it? Why was it relevant? And how did you search for it? More specifically, you need to record the date your research was carried out. That's especially important for internet sources where content can change or just disappear without notice.
Right.
For all primary sources, a full citation for legislation, case law, and other materials consulted is critical. This means knowing the precise reference, like the legal equivalent of a book's ISBN and author, so anyone can locate the exact document you used. For a book, you'd record the author, title, edition, year, and publisher. For a journal article, journal title, article title, author, year, volume number. For databases, the name of the database and the exact section you access, like Uganda Case Law and Uganda Legal Information Institute, for example.
So very precise location details.
Very precise. Beyond the source details, you should also note the keywords used during your searches. This helps you retrace your steps, maybe refine future searches, or demonstrate your search strategy if needed. Record page references, paragraph numbers, or direct website addresses for the key pieces of information you extract. And crucially, note the dates of publication for the source, including the date of the latest release for something like a loose-leaf source, and importantly, any dates to which the law is stated to be up to date by the publisher. These details confirm the currency and reliability of the information you're relying on.
That's a lot of detail.
It is, but it's necessary. The sources also mention that formal research plans and research logs are highly useful formats in legal practice for structuring this documentation. And for specific primary sources like case law, a structured case note or summary template is invaluable. This template guides you to record essential elements like the case name, the citation, the court, the quorum, the specific judges who heard the case. You'd then summarize the material facts, the facts crucial to the court's decision, detail any previous decisions, clearly state the issues the court addressed, identify the applicable law cited. The summary of decision gives the court's ultimate conclusion. It also requires listing other cases cited, both those applied and distinguished, identifying the ratio decidendi, that's the reason for the decision, the binding legal principle.
Hilario guys.
By any obiter dicta, those are judges' comments that aren't binding but can be highly persuasive, and any dissenting judgments irrelevant. This level of detail isn't just, busy work. It's about creating a bulletproof audit trail, ensuring accountability, reproducibility, and the ability to quickly refer back to your findings without having to redo the work. It's about building a robust, defensible foundation for your legal arguments and your professional integrity.
Okay, so legal research is clearly systematic, critical, incredibly detailed. But even with the best methods, it's not without its hurdles, is it? Our sources are very honest about some of the practical challenges researchers face, and it feels important to acknowledge those too.
That's a very important point, absolutely, because understanding the challenges helps you anticipate them, maybe mitigate them, and makes you a more commercially aware and effective researcher overall. One significant hurdle is simply expense. Quality legal reading materials, particularly subscriptions to those crucial commercial databases and specialized law reports, require significant money. That can be a substantial barrier for individuals, smaller firms, or even institutions in certain
A
regions.
cost factor.
Definitely. Closely related is scarcity. Some essential law sources are simply not readily available in all libraries or jurisdictions, especially maybe in developing regions. This can severely limit how comprehensive your research can be. Legal research is also notoriously time consuming. There are often just immense volumes of applicable materials to sift through, accessible in different formats. You often need to combine print and electronic sources. Sifting through all this takes significant time, patience, and that methodical approach we talked about.
It sounds like it requires real persistence.
It does. Then there's the issue of constant amendments, especially with acts of parliament. Laws are frequently updated, requiring continuous vigilance to ensure you're working with the most current version. Adding to this challenge, the fact that updates in the law are not always readily made on official databases and law reports. There can be a frustrating lag between a legislative change becoming law and its reflection in easily accessible resources. So you might need to look in multiple places to be sure.
That lag could be problematic.
It certainly can be. Finally, researchers are constantly faced with the practical dilemma of determining how much research a particular problem is actually worth in consideration of cost and time efficiency. You can't spend unlimited resources on every single issue, no matter how minor. You have to make commercially aware decisions about the depth of research that's proportionate to the client's problem and, frankly, the fees they are willing or able to pay. This highlights that commercially aware aspect of good legal research. It's not just about being thorough for thoroughness' sake, but also about being strategic with resources, both time and money, to deliver value efficiently and effectively.
Given everything we've discussed today, the meticulous process, the source distinctions, the real-world challenges, what are the defining abilities of a lawyer who truly excels at legal research? What does good legal research skills actually look like in practice, synthesizing all these critical elements?
Well, at its core, good legal research skills mean having the ability to meticulously analyze a problem that involves a question of law, and then, through rigorous research, provide effective, legally sound solutions. It's about moving from a complex legal question to a practical, actionable answer that directly addresses the client's needs. More specifically, this involves four key integrated abilities.
Okay, what are they?
First, it's the ability to identify and find relevant legal sources and materials. This means knowing what to look for and where to find it, navigating that vast and often confusing landscape of primary and secondary sources we've discussed. Second, it's the ability to extract the essential points from those legal sources. It's not enough to just locate a case or statute. You must be able to discern the critical legal principles, the ratio to sedendi, the key facts that make a precedent relevant. This requires critical reading and sharp analytical skill.
Finding the sources, then understanding them deeply.
Exactly. Third, a skilled researcher possesses the crucial ability to apply the law to the facts of the problem so as to produce satisfactory answers to the question posed. This is where true legal reasoning comes into play, bridging that gap between abstract legal principles and concrete client situations. It's where the insights from your research translate into practical advice. And finally, it's the ability to communicate the reasons for those answers, making use of legal sources and materials in a clear, concise, and persuasive manner. This includes that precise citation and logical presentation we talked about. What this ultimately underscores is that great legal research is the bedrock of critical thinking, synthesis, application, and communication, pretty much the full spectrum of legal acumen.
This deep dive has given us such a solid foundation, but learning is continuous, isn't it? Especially in a field as dynamic and ever-evolving as law. Our sources also wisely handed other valuable resources available for those looking to further hone their legal research skills and continue their professional development.
Indeed. The journey of a legal researcher is absolutely one of continuous learning and adaptation. Our sources mention various foundational definitions that highlight the sheer breadth of knowledge required, not just of the law itself, but of the tools and terminology of research. This includes understanding the purpose of an encyclopedia or a treatise, knowing about specialist databases like Heinenline, Google Scholar, ProQuest, JSTOR, or how to effectively use a periodical index, an open source database, a bibliography, or a research guide. It also extends to mastering basic navigational tools like tables of contents, indexes, forwards, prefaces, and even lexical aids like thesauri, glossaries, synonyms, and antonyms to truly refine your search terms and ensure you're capturing all relevant concepts.
So knowing the landscape of tools is key.
Absolutely. And crucially, the sources also point to the invaluable role of human expertise and institutional support, specifically highlighting librarian sessions. These scheduled sessions are designed to inform students and professionals about available library online resources, information literacy skills, how to access these resources effectively, the available law reports, the library catalog. They also often cover essential tools like reference management software, which is critical for organizing and citing research efficiently and accurately.
So don't underestimate the librarian.
Never. What this powerfully reveals is that even with all the amazing digital tools and advanced databases at our fingertips, human expertise like that of a dedicated law librarian remains absolutely critical for navigating the sheer volume and complexity of legal information, and for ensuring researchers are leveraging all available resources as efficiently as possible. It underscores that while technology certainly aids research, it doesn't replace the need for skilled guidance and continuous learning. Hashtag outro.
Wow, what an incredible journey through the intricate world of legal research. We've really peeled back the layers today. We've seen that it's far more than just searching online. It's a rigorous process of precisely defining problems, navigating authoritative sources with real discernment, applying critical thinking at every single turn, and meticulously recording your findings. From understanding that crucial difference between academic and legal research to mastering the five-step process, recognizing the ideal case, and documenting every step like a forensic scientist, it truly is the indispensable backbone of effective legal practice and sound legal decision-making.
It absolutely is. And this brings us to an important, maybe a lingering question for everyone listening. In a world where information is constantly evolving, legal systems are always adapting, and technology continues to reshape how we access knowledge, how will you continue to cultivate this essential skill? It's not just about knowing the law today, is it? It's about being prepared for the law of tomorrow, understanding its trajectory, anticipating its future interpretations. The ability to effectively research isn't just a static skill, it's a dynamic, lifelong pursuit.
That's a great thought to end on. Thank you for joining us on this deep dive. We hope you feel much better equipped to understand and truly appreciate the power and precision of good legal research. Keep that curiosity alive, keep honing those critical skills, and always, always keep digging.